lot of papers, legal and physical issues. Chapter 12, Leasing Property. In this chapter, understanding some lease jargon, seeing what goes on in a lease, looking at different types of lease, find out about breaking a lease. Chapter 12, Leasing Property. As a real estate agent, you may represent the owner of an apartment building, office buildings, or retail buildings, like shopping centers. As a leasing agent, leasing activities is an essentially important part of the property management and commercial real estate work if your real estate career goes in that direction. Just as you can represent a buyer in a sales transaction, you can also represent a tenant who someone else is seeking to rent an apartment or commercial space. In a leasing transaction, state real estate exam writers expect you to know the basis of leasing. You can answer most of these questions if you simply have a clear understanding of the different relationship definitions. In this chapter, I talk about various kinds of estates, interest in real estate, and connections with leases. For a more complete discussion of real estate and interest, see Chapter 6. I also give you some information about the requirements of a physical lease agreement and the different types of leases, and in some ways people break these leases. I also cover some unique details of commercial space leasing. In this chapter, I sometimes use the term apartment, which could mean a garden apartment, a duplex, a single family house as a rental. I also use premises, which is a common word used to describe the defined piece of land, building, apartment, or other space. Identify who's who and what's what. When you read this section, remember that I simply cover the basic definition and terms connected to leasing. I also give you some information about the different interests, estates that exist with respect to leases. State exam writers want you to be able to identify terms and apply them to pretty simple cases. Owning property, lease fees, estates. A lease is an agreement between two parties for possession and use of a particular space, usually for a certain length of time. The person who owns the space usually refers as a landlord. It's technically called lessor. The landlord owns what is called a fee in the property. For more in-depth information on fee simple interest and various rights of ownership, see Chapter 6. A lease separates two of the rights of ownership and possession. The owner still owns the property, but has given possession to the tenant, the lessor. Owner's lease in the property in a lease situation is called a leased fee estate. Lessor is a revisionary right to repossess of the premises when the lease expires, which simply means she gets possession of the property back. Sometimes the owner's interest is referred to as a leased fee estate with revisionary rights. Renting property. Leasehold estates. A tenant interest in the property is called a leasehold estate. Another term for a tenant is a lessee. The tenant holds the lease, whereas the landlord gives the lease. In each of the following four types of leasehold estates, I use the term estate. However, note the word tenancy can be substituted in each case. Estate for years. An estate for years is a lease agreement with a definite starting and ending date. A tenant is required to leave when the lease expires, and a landlord isn't required to give the tenant notification to leave the premises. Neither is a tenant required to give notification to the landlord that she's leaving. Commercial property leases generally create an estate for years. No automatic renewals of an estate for years is available, but a new lease can be negotiated. Also, the agreement survives the landlord's death or the sale of the property. Note, in spite of the name, the lease could be for a term shorter than a year. Periodic estate. A periodic estate, also called an estate from period to period or periodic tenancy, occurs when an original agreement doesn't contain any defined period of time. A month-to-month tenancy is an example of the periodic estate. Though the period can be week to week or for years year to year. Essentially, the agreement automatically renews itself from period to period, with the original terms and conditions remaining in effect unless the landlord and tenant negotiates an agreement. In some parts of the United States, periodic estates are commonly used in a residential lease. A periodic estate can be created when the estate for years. Remember, a lease with the ending date ends. The tenant does not move out, and the landlord continues to accept the rent. The tenant may be referred to as a holdover tenant. Estates at will. An estate at will is when a landlord allows a tenant to occupy the premises, but there is no definite period of time when the arrangement will expire. The owner about to sell a building may allow a tenant to occupy an apartment under the type of arrangement. The estate at will can be terminated at any time with the proper legal notice, usually defined by the state law, and it ends if the landlord or tenant dies. Estate at sufferance. An estate at sufferance occurs when a tenant who has a legal right to occupy the premises continues to occupy the space after the right of occupancy has expired. Against the landlord's will, one example is a tenant who continues to stay in an apartment after the lease expires. The tenant is sometimes referred to as a holdover. No actual tenancy exists because the landlord is not accepting rent. In the event of the property sale or the death of the landlord, the new owner has the same rights as the original owner to seek eviction. See breaking and lease, types of eviction, later in this chapter. An estate at sufferance can be converted to a periodic estate, which I described earlier in this chapter. If a tenant pays the rent and the landlord agrees to accept it. The usual suspects preparing a typical lease. Because a lease is a legal document, I recommend that landlords have an attorney prepare a lease. On the flip side, when signing a lease, I recommend that a tenant and attorney review it. Even fill-in-the-blank leases forms should be reviewed by the attorney. In this section, I focus on the requirements for a valid lease. Some of these lease typically provisions and lease related to leases. Laws related to leases. Looking at laws govern leases. The statute of frauds, which all states have adopted in some form, usually requires the lease for the term longer than 1 year be in writing. In Chapter 11 for more, see states that have adopted another law, the Uniform Residential Landlord and Tenant Act, which provides additional terms and conditions that could be addressed in a lease. In the following sections, I give you some of the requirements that many states use as a minimum for a valid lease. The Uniform Residential Landlord and Tenant Act also provides protections for both landlords and tenants. Check out the states and local municipality laws to determine if any provisions are applicable for specific tenants' rights. Laws also govern rent control, which is sometimes used as a generic term for any type of government control over the landlord may charge a tenant. These laws generally govern residential units and vary from state to state and city to city. Check out if any type of rent control exists in your state. Examining typical provisions of a lease. A lease is a form of real estate contract. And general information on the contracts, see Chapter 11. Like all contracts, a lease needs to have a few items to be considered valid. The main provision of a valid leases are legally competent parties, also referred to as having the capacity to contract. The provision means that someone signing a lease has met all the legal requirements of age and competency. Mutual agreement. The lease must include an offer and acceptance of the terms. All parties must clearly understand the terms of the lease. Legal objective. The provision states that what is being contracted for is lawful. Consideration. The exchange of space for money or other items of value must be enough to make this a valid lease. The consideration could be in a form of service, such as a janitor being given an apartment in exchange for working in the building. Agreement in writing. Depending on the provision, in your state's provision in the statutes of frauds, the lease may have to be in writing. Typical leases is more than a year have to be in a written agreement. Your state may have additional specific requirements for a valid lease, so be sure to check. Although the minimum requirements technically create a valid lease, they really don't provide useful or specific details. Most leases also contain the following language to clarify certain details. A description of the lease promises. This could be an apartment number or floor number. It may include an actual survey description if a piece of land is leased. I cover property description in detail in Chapter 9. In a non-residential lease, the description could indicate a drawing that shows the dimensions and locations of the space within the building. The term of the lease. The lease typically provides a beginning and end date. The amount and date rent payments. The statement includes how much the rent is, when the rent is due, a grace period that may be offered, penalties for late payments, and where the rent is to be sent. Check out when the default rent payment date is on your state. Lease provisions typically require rent to be paid in advance on the first of the month. The default position is in some places is that the rent is due at the end of the month for the previous month in arrears. Provision for rent increase. Leases sometimes have provisions in automatic rent increases at a certain interval, which is sometimes called graduate lease. Rent increases to be tied in the consumer price index and the index that measures price increases in inflation, in which case the lease may be referred to as an index lease. The amount of security deposit. The lease provision provides the deposit amount and clarifies when a landlord must return it to the tenant and at the end of the lease. State laws vary as to how security deposits may be used. For example, in some places, but not all, they may be used to cover default on the rent. State laws or local ordinances may require that the security deposit be returned to the tenant within a specific time period. An explanation to be provided as to why all the portion isn't being returned. Find out the relevant time frames, if any, in your state. How the premises can be used. A landlord can limit how the tenants use the lease space. For example, commercial spaces can be used for living quarters. Whether and how improvements can be made. Improvements to a space are often part of a commercial lease, but also may be part of a residential lease. Whether the landlord and tenant does the improvements is a matter of negotiation. Typically, residential tenants are permitted to make improvements with the landlord's permission and are required to return the space to the original condition at the end of the lease. Provisions outlining maintenance responsibilities. Landlords are generally required to maintain the premises is unusable in what is called a habitual condition. Certain commercial leases may require tenants to pay for the assumed certain maintenance responsibilities. Details and destruction of a property. In case where the tenant is leasing the landlord or has a building on a leased land, the tenant may be responsible for the building and other structures that are destroyed. Tenants are usually responsible for the destruction of a building in which they lease only a part of the space. They could, however, also be responsible for the business equipment and personal items, just as a renter or residential is responsible for their personal item insurance. Provisions for occupancy limits. Depending on the state or local laws, a landlord may or may not be able to limit occupancy of the unit to the tenant who is signing the lease. Provision for or against subleasing. The leasing may provide for the renting of the space by the tenant to a subtenant through what is called sublease. A sublease between the tenant and is taking over the lease. This is called an assignment. In a sublease, the original tenant is still liable. An assignment is when a new tenant usually needs the approval of the landlord, even though the original tenant may remain liable. Termination and sales clause. Under normal circumstances, if a landlord sells the building, the lease survives the sale and a new owner takes possession subject to the lease. If the lease contains the termination or sales clause, however, the new owners can evict the tenants upon proper notice and renegotiation the lease with the tenants. the right of a quiet enjoyment. Whether stated or not, a lease generally conveys to the tenant the right to quiet enjoyment. A legal term that means the tenant has exclusive use of the leased premises without interference from the landlord. The landlord usually can't enter the premises without the tenant's permission except in an emergency. Any options. A lease also can contain a renewal clause guaranteeing the tenant the right to renew the lease or purchase option, giving the tenant the right to purchase the property at or before the end of the lease terms. Distinguishing among various types of leases. Though different types of leases have common features and have the same minimum legal requirements, they serve different purposes. The following section can help you distinguish among the different types. Exam questions will likely focus on the major traits in various leases and may use short case studies to ask about types of leases used under certain circumstances. Gross lease. A gross lease is where the tenant pays the same rent each month and the landlord pays all the building expenses, such as maintenance and taxes. The landlord may also pay some or all of the utilities, but in some gross leases, the tenant may pay his own utilities. The typical apartment lease is a gross lease. Ground and land lease. The ground and land lease, or land lease, is a lease where someone rents an empty, vacant piece of land specifically to erect a building on it. These leases tend to be long-term and often extend 50 years or longer. This lease term allows a tenant time to make the investment in the building worthwhile. In a ground leasing, the tenant owns the building and the landlord owns the land. Ground leasing usually requires the tenant to pay all property expenses such as taxes, utilities, maintenance. In this respect, the ground and land lease is similar to the net lease. Lease for oil and gas rights. Some leasing companies the right to search for and extract oil and gas from someone's property. Tenants usually pay a fee for the lease, and then additional money is paid to the holder of the lease of the rights and the property owner according to how much gas or oil is removed. This type of lease is considered to be limitations or cloud on the property or title to the property, which anything that limits the right you to get when you buy a piece of property. Net lease. A net lease is one in which the tenant pays the building expenses on top of the base rent. Whether the tenant pays all or some of the expenses is negotiable. A triple net lease, sometimes referred to as a net lease, generally requires the tenant to pay all expenses such as taxes, utilities, maintenance, and insurance. And a net or triple net lease is commonly used in renting commercial spaces. You may want to check whether a double net lease or a net lease is common in your area. In some markets, a tenant pays 2 or 3 building expenses like taxes and maintenance, or taxes and utilities, but not all of the other expenses. Percentages lease. A percentage lease usually has a minimum monthly rental charge plus a percentage of the gross earned by the business. The arrangement is sometimes used in a lease with the retail store, and the percentage is based on gross sales. The percentage lease may be either a gross or net lease, meaning that the tenant pays none, some, or all the building expenses. Proprietary lease. A proprietary lease is a lease that is given to the owner of a cooperative apartment. The owner doesn't usually own the apartment itself, but rather shares in the corporation that owns the building. He receives a proprietary lease that allows him to occupy the apartment. For more on cooperatives, check out Chapter 7. Variable lease. A variable lease allows for the rent to change over the life of the lease. A graduated lease is a variable lease in which a pre-agreed to rent increases occurs on specific dates. Another form of variable lease is the index lease. Ties in the rents increase and decreases in the index, such as the consumer price index, and set intervals. Breaking a lease, types of evictions. When a lease expires, unless a tenant or owner negotiates it, the tenant is required to leave the premises. However, under the circumstances, the tenant may be forced to leave either by the landlord or by conditions in the building before the lease terms expire. The two main types of evictions are as following. Actual evictions. Actual evictions occur when a landlord sues for possession of the premises. This usually occurs when a tenant violates the terms of the lease agreement and stays in the premises beyond the lease expiration date. Construction eviction. Construction eviction occurs when landlord actions are such that the premises become uninhabitable, and landlord consistently over time not providing sufficient heat during the winter months may result in a constructive eviction. In such case, as soon as the lease premises are proved to be unusable, the lease is considered ended. Don't consider this a good way to get rid of a tenant. Such actions by a landlord are illegal. Getting what you pay for. There are somewhat unique situations that happen when you rent non-residential spaces. It's a perfectly legal and accepted practice, but the fact is that you may not actually get what you are paid for. Read on to learn more about this concept. Non-residential building layouts. Think about the last office building you visited or the one you work in. Maybe it has a nice spacious lobby, some elevators, wide hallways, men's and ladies' rooms, and finally some separate office housing doctors and lawyers and accountants and other businesses or professionals. The same goes for the last shopping mall you went to. Only the time and space is divided up into stores instead of offices. It's logical that each of these tenants in the building pay their individual office space. But they claim use of the lobby, the hallways and the washrooms and the elevators. Who pays for that? Commercial property landlords and tenants understand that the so-called common spaces in these buildings have value and are necessary for the building to be function properly. And it will be relatively easy for the landlord to simply recoup the cost as part of the rent, the way apartment landlords do, if the individual's rented space was more or less the same size. But the tenant renting a 1,000 square foot office would feel that it's unfair if he had to pay the same for the use of the common space as a tenant renting $5,000 square feet. What has developed to solve this problem is the concept of rentable and unusable space. Rentable space. Rentable space is the space that a tenant pays for when renting non-residential space. Say in an office building or shopping mall, it generally contains more square feet than a tenant is entitled to use exclusively. It takes into account the common space used by the tenant and the tenant's visitors. The rent is generally stated as so many dollars per square feet annually, even though it might be paid monthly. In some cases, it's stated that the monthly rent is either case. It is multiplied by the number of rentable square feet to arrive to the total annual and monthly base rent. Unusable space. Unusable space is the square footage that the tenant is allowed to use exclusively. It is a space behind the door of the hallway. It is the invaluable less than the total square footage the tenant pays for. Adding and taking away space. Taken away. The difference between rentable space and unusable space is called add-on factor or the loss factor, depending on which way you do the calculations. It's pretty easy to remember. The add-on factor is adding on unusable square footage to arrive to the rentable total square footage. The loss factor is subtracting for the rentable square footage to arrive at an unusable total square footage. Both are usually stated as percentages. Following are a couple of simple examples that you probably won't have to do on exam, but they help demonstrate the concept. Loss factor: 5,000 square foot rentable space times 10% loss factor equals 500 square foot loss space. 5,000 square foot rentable space minus 500 square foot loss space equals 4,500 square feet usable space. The add factor of 4,500 square feet usable space times 10% add-on factor equals 450 square foot proportionate common space. A 4,500 square foot usable space plus a 450 square feet proportionate common space equals 4,950 square feet rentable space. Note that using the same numbers, the 10% has a different result depending on whether it's used as an add-on factor or a loss factor. And that was part 4. A house is made up of lots of paper. Legal and physical issues. Chapter 12. Leasing property. Thank you.